Qantas, our national airline, has been using its clout to push social causes for a long time. Its boss, Alan Joyce, was very prominent, for instance, in pushing same-sex marriage. But could Qantas now end up in court over the sacking by Rugby Australia of superstar Israel Folau for quoting the Bible against gays? You see, last Friday, Rugby Australia Chairman Cameron Klein said, well, they'd had to sack Folau because their sponsors, and Qantas is the biggest, had made clear it would have dumped Rugby Australia if they did not. No Folau, no sponsors. But a company, let's call it hypothetically Qantas, that encourages someone to breach a contract could be liable at law. And Sydney barrister Jeff Phillips, senior counsel who specialises in employment law, has said there may also be a breach here of Australian competition laws which ban things like secondary boycotts. Is any of this true? How much trouble is Qantas in? Joining me is Alan McDonald, Managing Director of McDonald Merhome, a leading employment law firm. Alan, thank you so much for your time.
Nice to be here, Andrew.
Well, how much trouble do you think Qantas is in?
Well, it'd be interesting to see whether they've actually been named as being involved in the contravention, because the law does not want external parties entering contracts of employment like this and taking away people's jobs. The whole purpose of the Fair Work Act is to preserve employment. That's its primary objective. That's why when Folau makes his claim, he should be demanding reinstatement, and he probably is, because we want in this country all hands on deck. Whatever your religion, whatever your political views, whether you're pregnant, whether you're coloured, whatever you are, that's the primary purpose of this legislation, I say. And what Qantas is doing is setting itself apart from that and saying, well, only if it suits us as the sponsor.
Yeah, but let's first be fair to Qantas, OK? So Qantas's boss, Alan Joyce, he denies that Qantas called for Folau to be sacked, but he did admit, and I'm quoting him here, we asked Rugby Australia, what are you doing to make sure we're not involved in controversy? And now Rugby Australia's suggested that what it the message in fact got was if they employ Folau, there'll be no sponsor. So slightly different. Do you think Qantas, on even Alan Joyce's account, is in trouble?
Well, it'll depend on the judge, of course, but it could be because it's the judge's job to draw the inference. Was by those comments Qantas really clearly signalling to Rugby Australia, this man has to go? I mean, it might have been putting it in polite language, as it says, but is the inference that Rugby Australia is to draw the one that it did draw, and that is say, this man has to go? And that's
You're right, it didn't draw exactly that inference. That's the problem.
And that's what the judge is meant to be able to do. He's meant, or she is meant to set up the evidence and decide whether or not that is the proper inference, whether they involved. If they were involved in that way, then they can suffer some penalties, because what Folau's doing is effectively prosecuting a claim. He's not just a civil litigant who's seeking money. The Act gives him the power of prosecution, so that if he was to go all the way and get a fine imposed upon Rugby Australia, he would be the person collecting the fine. Now, that's unique. That doesn't normally happen. You don't get the local copper collecting the fine when he books you. But because the government has charged Folau and anyone in his position with such an onerous responsibility, then it allows the penalty to go. And we've seen penalties of $45,000 more than once in cases where political opinion is breached. You're probably aware of the case against the CFMEU. I know you're interested in that organisation, where they were fined $45,000 because they allegedly sacked someone because of his political opinion. You could see the same thing happening here, I imagine.
But Alan, you know, I've got some sympathy with a sponsor, right? A sponsor wants to sponsor a sport that makes them look good, right? Now, if they're sponsoring a sport, then Alan Joyce, whether it's his personal opinion, put his personal opinions to one side. If Qantas is then being attacked by the social justice brigade, oh, how could, you know, you look terrible sponsoring something that has Israel Folau there, then of course they don't want to, maybe they would feel that's reputational damage. We don't. In fact, why should they sponsor?
Well, you've got a good point, and there are exceptions to every rule. So just as you might expect, if they say that the inherent requirements of a job with Rugby Australia is that you keep on the right side of your sponsors, and they put that forward to Folau when he comes in, because let's face it, without the sponsors, where does Rugby Australia get all the money from to pay these very high salaries? So it would not be exceptional, you would think, that Rugby Australia might say to its players early in the piece, I'm afraid it's an inherent requirement of your job that you don't offend our sponsors, because they're paying the salaries here. And they might do that at some stage, because that might be something that's open to them. That's not what I've heard so far in this case, but it might be what they're going to argue in any event.
Now, I've heard people say, employment law experts that I respect, say this is just strictly a contractual dispute. It's nothing about freedom of speech. You signed a contract that says, you don't start offending sponsors. I'm not sure that is the contract, by the way. But anyway, that's the deal. Was he in breach of a contract? And if by saying X, which was quoting the Bible in this case, is a breach of contract, Rugby Australia is absolutely, fine to then sack him. But my point is this: it is still a freedom of speech thing. Since when does quoting the Bible mean you've acted so abhorrently that, of course, a sponsor would be horrified? So you can have both in this case.
You absolutely can, and the law overrides the contract because you must have freedom of speech in every respect. I mean, people must be free to complain within the workplace about, for example, occupational health and safety issues, about bullying issues, about a range of issues, and they can't be sacked if they make certain complaints. That's part of this whole adverse action general protections law. Because in this country, we want people to have free speech, and that's why we don't want the employee with a very low bargaining power against these now large multinational companies. And that's when this law came in. I think you could link it to the globalisation of Australia. In 2009, we were really ramping that up, and that's the time this came in, to protect Australian employees against this sort of influence by foreign corporations.
Because they're taking so much of our private lives away. There's so many companies now are insisting that you do nothing in your private life that will offend them, that will hurt their reputation, whatever. Why it should, I do not, in many cases, know. But it goes into things like what you might say, what you might post, what rally you might go to, what positions you might hold on publicly on social issues. I mean, it seems to me that we're almost becoming serfs again in some... I exaggerate slightly, but the tendency is there.
Oh, no, it's a very strong tendency if it's not controlled. And, it's interesting, isn't it? The churches used to exercise a lot of power over the Christian community. They would tell people what they could and couldn't do. The churches have lost a lot of influence, especially recently, and through events that have been most unfortunate. And at the same time, you've seen these companies rise up with all their policies and procedures, which are really a set of moral values, which one would doubt that they should be imposing on individuals.
So who indeed made Alan Joyce Pope? But, money did, I guess. Alan McDonald, McDonald Merholm, thank you so much indeed for your time.
Pleasure.